It's March 12th, 2026, and this is the Court Gallery. Ladies and gentlemen, what happens when you make terrible life choices and then have to explain them to a judge? Spoiler alert, it does not go well. Today's compilation is absolutely wild. I've got a guy who actually showed up to court drunk at 11 a.m. and tries to argue with the judge. Another judge who goes on an epic rant against the guy making excuses about getting a job. And a defendant who casually admits to having a whole pharmacy in his system during his arraignment. We have Judge Simpson, Judge Oakley, Judge DeSanto, and they're all out of patience today. And ladies and gentlemen, it all starts right now.
Court calls the case, People versus Ada Olive. Is she in? He's in too. Got it.
Morning, Your Honor. Ricky Cook for the people.
Miss Olive, can you state who's her attorney?
Miss Russian.
Miss Russian.
Good morning, Your Honor.
Oh, okay, there she is. All right. Good morning, Miss Russian.
Good morning, Judge.
Miss Olive, can you state your name?
Ada Olive.
All right.
I apologize, Judge. I was waiting for her to walk to the podium. Sydney Russian appearing on behalf of Miss Olive. I am sitting in for her attorney of record, Mr. Brandon Burnett, and that's with Miss Olive's permission. Is that correct, Miss Olive?
What did you say? I'm sorry.
Sydney Russian, remember me from last week?
Okay, yes.
And Your Honor, Mr. Bird is remaining on one matter. I do note that there was a substitution sent in on one of the cases and it was adjourned. So we're asking to adjourn this matter to whatever date that PCC was sent to. I think it's going to be put 2 weeks out.
Miss Olive, it's another one for Miss Olive, you mean?
Yes, she had two that were up for today. I believe that we are remaining on, let me get the exact correct one and I can make sure that the record's clear. I apologize.
No, it's okay. Mr. Cook, she has another.
Yes, Your Honor. So there's a substitution of attorney on the file ending in 0173. I've been informed by Miss Olive's father today that they intend apparently on retaining that attorney on her remaining case. Also,
Got it.
That other one was adjourned to
March 26th. Close.
Oh, okay. So it's probably 2 weeks out. My staff just informed me, believes it's March 26th.
that sounds correct.
All right. Probable cause conference in this case then will be adjourned to March 26, 2026, 9 a.m. Bond will continue. If for whatever reason we have those dates wrong, just contact my staff and we'll make sure that they match up. All right.
Thank you so much, Your Honor.
Thank you. Thank you, Miss Olive.
Thank you.
Okay, so the People versus Shantanique Sims.
Oh, good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Shantique Sims, who's approaching.
Oh, for me to correct something, or it's just,
It's not. It's just.
all right, very good. All right,
Your Honor, sorry, go ahead, your name then.
Shantique Black.
okay, got it. That's what the right note was.
Your Honor, I just received this case yesterday. I'm requesting a 1-week adjournment for discovery.
Sorry about the phone.
Probable cause conference will be adjourned March 19th, 2026. Yes, that's the bond.
And this time I'm going to be asking for the defendant's phone texting privileges to be revoked. There were 76 calls to the victim's limited number after being arraigned from the defendant's pin. So this time I'm going to be asking your phone privileges to ask privileges for your vote.
Your Honor, first time I'm hearing about this morning. Obviously, I was not made aware of this before going on the record today. I don't know the nature of those calls. I'm assuming that was a bond conditions, but obviously,
What I will do, and certainly after getting the information, you can request a hearing on it, but at this time, I'm going to revoke the defendant's phone and texting privileges.
And I apologize, Your Honor, it was not the list number of police report, it was the number that we have had contact with victims on.
Got it. All right. See you next week. Thank you.
I'll see you this weekend. You gotta go into that.
Court calls the cases of the people versus Raisha Anderson.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Jay Bellinger on case that not ending in 5330, Your Honor. Mr. Anderson, up here's next to me. Mr. Anderson, can you please state your name for the record?
Raisha Anderson.
I apologize.
And good morning, Your Honor. Sydney Brushing, appearing on behalf of Ms. Henderson. I am standing in for her attorney of record, Mr. Brandon Bird. Mr. Anderson, that is with your permission. Is that correct?
Yes.
Thank you.
And Your Honor, we are just seeking an adjournment on all of these matters. We did just submit a mitigation over to Mr. Cook. He approved us for, he'd like us to refer her to the mental health treatment court. So we just need time to do that.
Got it. Is that a correct
And we're
statement?
joining that request.
All right. I'm not sure how long they're taking or what it is, but I'll adjourn these to April 2nd. That's the 2026, 9 a.m.
We'll get that done for you as soon as possible. Okay. Okay. I'll work on that today.
All right.
Your Honor.
You might as well.
Thank you, Your Honor.
Court does call the case of the people versus Terry Williams.
And good morning, Your Honor. Sydney Brushing, appearing on behalf of Mr. Williams. I am standing in for his attorney of record, Mr. Brandon Bird. Is Mr. Williams in the courtroom, Your Honor?
Not checked in.
Okay, Your Honor, at this time, I know that Mr. Williams is not checked in. Would Your Honor consider passing so I can try and get in contact with Mr. Williams?
Your birthday? No, your birthday is a.
No,
Ms.
not
Rushing.
even close.
Okay, then I'm not passing. It's the only way.
But
That's
Judge,
what.
it's almost
Mr.
313
Ellman
day.
said-
That's something, right?
What?
I said it's almost Detroit Day, 313 day. That should be lucky or something. It's a special day.
I'll pass it.
Thank you, Judge.
I'll pass it. You find them. It's gonna be a long day. Court calls the case, people versus Deshaun Gainey.
Your Honor, I'll tell you what I'm legal.
And good morning, Your Honor, Assistant Public Defender. Denazi Carey, I can really on behalf of Mr. Deshaun Gainey.
Warnings. Afternoon.
Mr. Gainey, could you state your name for the record, please?
Deshaun Gainey.
Thank you, sir.
Your Honor, I do have a green sheet. We're asking for an adjournment today. Unfortunately, I have not been able to make contact with Mr. Gainey, but people have extended an offer, so I'd like to review that with Mr. Gainey.
26 of the second would be.
26, Judge.
Probable cause conference, March 26, 2026, 9 a.m. Bond will continue.
March? Yes,
Oh,
straight out the
were
gate.
you in a different month?
I was,
With there?
I was in,
Okay, all right, no, never mind. Never mind. Didn't know where you went. Send the Elman's clients and Zoom. His birthday's tomorrow, so we'll call it tomorrow. Yeah. Court calls the case, people versus Jeffrey Ball.
Your Honor, Raymond Cook for the people.
Sorry to wake you up. No, go ahead.
Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Where's Cannon? And quiet. Oh, okay. She's here.
Yes.
Permission to practice is granted.
Thank you. Your Honor, in this matter, we would like to adjourn for mitigation purposes.
Ball. Mr. Ball, can you state your,
My name is Jeffrey Ball.
thank you. Why is? Why is he at our access point, not down here in the courtroom?
I'm not sure.
Mr. Ball, is there a reason you didn't come down to the courtroom?
They told me to come video Zoom.
Who told you, your attorney?
The lady who checked me in, yes, she told me to come down here and video Zoom. When I came in, she set me down, she sent me down here. Excuse me, Your Honor.
Probable cause. No, you're good. Don't worry about it, Mr. Ball. We know where you are. Probable cause conference. Bless you. April 9th, 2026. 9 a.m. Fun continue.
Thank you, Your Honor.
Thank you, Mr. Ball.
Thank you, Your Honor.
Court calls case of the people versus Larry Evans.
Families and on behalf of the people, Your Honor.
Assistant Public Defender Gia Bellinger on behalf of Mr. Evans, who is approaching. Can you state your name for the record?
Yeah, Larry Evans. Thank you.
Thank you. Your Honor, we were just asking to set this matter for preliminary examination, discovered complete to the best of my knowledge.
People have their witnesses available the 24th. You might be. Preliminary examination will be set for March 24th,
Is that what you want me to do?
2026, 9 a.m. before judge. For me,
Your Honor,
yes.
if I may briefly address bond. Your Honor, my client is asking for release on PR. He advises that he is just trying to get back to work at this point. He advises that he would be able to and willing to obviously show up for his preliminary examination. This is a matter that he certainly wants to handle and take care of. He does have a place to stay locally. He's got family that supports him. Is that all correct? And
Yes, it is. Response.
Strong object. He also has bowled out of Detroit for retail fraud, bond denied, and larceny in the building. This is an extremely serious case in which the victim was at the defendant's apartment trying to leave, and he told her no, threw her on the couch. He then told her to sit down before I kick. She was able to use the phone to tell a friend to call 911. He then took that phone and went to the bathroom with it. She then ran to try and escape the apartment, and he wrapped his arms around her neck, pulling her back to the apartment by her neck and her hair. While inside, he then dragged her into a bedroom, threw her on the bed, and then strangled her, saying, "Bitch, I will kill you." He eventually stopped strangling her and told her she could leave, but when she tried to leave, he closed the door and again threatened to kill her, and then grabbed a 2x4 and raised it as it hit the victim. She had bruising, red marks, and making herself from this instance, so I'm going to strongly object to anything.
Anything else?
just looking at the size here versus the allegations, Your Honor, I'm not sure how all of that was very easily accomplished. Obviously, they're allegations at this point. So again, I'll just,
Had a hard time doing exactly that. I should,
I'm not saying that he at all, obviously.
for bond reductions. Bond will continue.
Right. Be in touch.
It's his birthday. No, I'm every week. This one now. Court recalls the case of the People versus Terry Williams.
Again, Your Honor, Raymond Cook for the people.
And good morning, Your Honor. Sydney Brushing appearing on behalf of Mr. Williams. Mr. Williams, can you state your name for the record?
Terry Williams.
And Mr. Williams, can you start your camera?
Okay.
And also, Mr. Williams, I'm standing in for your attorney of record, Brandon Burton. That's with your permission. Is that correct? Morning, Your Honor, Justice Side number 81798.
I'm trying to connect my camera. I don't know what's going on. It's not letting me turn on my camera.
All right, I'll let it pet. What are we doing?
Your Honor, we're just seeking a brief adjournment. I know that there's going to be a waiver executed in this matter. I just didn't have an opportunity to get the paperwork signed prior to today's date. So we're just asking for a brief adjournment so that paperwork can be executed.
Probable cause conference, March 19th, 2026, 9 a.m. Sir, if you appear via Zoom, you will have to make sure that you have a camera. You understand that? Otherwise, you need to be here in person.
Yes, sir.
Bond will continue. Thank you.
Thank you so much, Your Honor.
Court calls the case of the People versus Kenzie Dunn.
Michael Gaddy, Assistant Public Defender, on behalf of, take your way to the podium.
Your name?
Oh, I'm sorry, Kenzie Dunn.
Your Honor, I have submitted a green sheet. We're asking for an adjournment. Ms. Dunn has a assessment at the Sacred Heart treatment facility tomorrow. I do have a verification here. It's the Sacred Heart program that's up in Richmond, which I think is up in northern Macomb County. It looks like it's their model is a 12-step type approach. It is inpatient.
On an amphetamine of some type?
Excuse me, Judge?
On an amphetamine of some type?
You mean prescribed?
Have,
Yeah, I don't believe so, Judge.
this should be clarified. So why is she testing positive for amphetamines?
Your Honor, I believe this was the initial test after arraignment. We are asking for an adjournment
Will she
for.
test clean today?
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
I think she's. It's my understanding she doesn't know the half-life of it, Your Honor. I believe her initial test was
That was she
the 6th
saying?
or the 5th. Well, she
When's
said
the last time did you use?
It was a couple days ago. That's why I'm seeking in-house treatment. Your Honor.
Your Honor, I do have, documentation here that she is seeking to address the root cause of any of this behavior. Like I said, she has an intake tomorrow. I can, it's at 1 p.m. That's in Richmond. She is here, this issue today. I offered to the.
If she tests on the 6th, she's positive on the 6th. I'm now here on the 12th. And she's using by the 10th. I have no guarantee that she's gonna make it even to treatment.
Yeah, I promise you, I will have my 4 kids with me, sir, Your Honor.
You know, she has a lot at stake.
I understand that, including her life.
Yeah, sure.
I'll adjourn the probable cause conference. March 19, 2026, 9 a.m. This time the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court calls case People versus Mamadou Kaba.
William Amadeo, P76194 for Mr. Kava. Please state your name.
I'm Kaba. Okay, turn this way. All right, what are we doing?
They're just setting this for a prelim.
Discovery is complete.
I believe so. Yeah, I know. Judge, I just want to make a record. We don't get a prelim today. We need it at the earliest date, please. I want my client to make sure he knows that. Since this is a probable cause conference, you can't, no, we're not adjourning anything. We're just going to the prelim.
You have all the discovery.
I believe so, sir.
You will have their witnesses available the 24th. Probable cause or preliminary examination will be set in person, March 24th, 2026, 9 a.m. That's before
Thank you.
before Judge Fresh Hour. Bond will continue.
Thank you.
Thank you.
I need this.
Court calls case People versus Dallas Fritz.
And on behalf of people, your honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Fritz, who should hearing via Zoom from treatment, Your Honor.
Dallas Fritz.
Hello.
Hello. I need a camera.
There
Oh,
we go.
There you go. Okay.
All right, Your Honor, we were otherwise prepared for a plea today. However, we understand that Mr. Fritz has some significant issues in Oakland County in terms of his probation that he wants to look into prior to taking the plea here to see what the consequences might be. So we would just be asking for 3 weeks. We've all been trying to reach out to his probation, including him.
Oakland.
Yep.
He's currently in treatment.
That's my understanding, yes.
Is that right, sir?
Yes, Your Honor.
All right.
Do you have a potential release date, Mr. Fritz?
Not as of right now, but I can get that probably today if you need it.
Okay, great. All right, thank you.
Probable cause conference, April 2nd,
Thank you very much, Your Honor.
2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir. Court calls versus Theophilus Smith.
Fourth Mr. Assistant Public Defender on behalf of Mr. Smith. Mr. be there for the record.
Theophilus Smith.
Okay, Mr. Childers and I approach briefly.
May.
Just sign here for the waiver.
Waiving on both cases. All right, Mr. Smith, you're waiving your right to a preliminary examination in these matters?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
Understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
We'll also waive the right. Preliminary examination having been waived, defendants bound over to circuit court on the single count in both cases.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for.
March 24th at 1:30 with Judge Conklin.
Why don't you give me
Okay.
May 12th, 2026, 1:30 before Judge Conklin.
Thank you, Judge. If I might.
As to bond.
Thank you, Judge. Obviously, I've spoken to the people on this matter and to my client. My understanding is Mr. Smith has already had things set up through my office for if he should be released. He has worked with our social worker, Jules. He's also been in contact with Ms. Stewart in the county jail. He has CMH set up. He has housing set up. What I'm asking the court would consider releasing him on a personal bond and give Mr. Smith the opportunity to show to this court and to the people that he can be compliant on his pretrial date, should that May day, and I think that might help this matter resolved, and he can show that he can stay out of trouble, Judge.
Any response from the people?
No, nothing be empty.
You're gonna be able to stay out of trouble if I let you out?
Yes, sir.
All right. Are you you're working with CMH, right?
Yes, sir.
Okay. If I let you out, Theophilus, you gotta make sure you're working with them.
I will, sir.
You do that for me?
Yes, sir.
I'll grant the motion for a bond reduction. I'll reduce the defendant's bond to a $10,000 personal recognizance bond. He's to comply with CMH requirement, his CMH program.
Thank you very much, Judge. Good luck to you, sir. All right. Okay. That's all. Judge.
Court calls case People versus Cedric Green, no relation.
Ready, Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. Green. If he hasn't already done so, Mr. Green, please state your name for the record.
Mr. Green, you gotta unmute. You're on a phone, so hit *6. Cedric Green, you gotta unmute. You need to hit *6 on your phone. Oh,
Can you hear me now, sir?
yes, I can hear you. State your name.
Okay, I'm sorry. My name is Cedric Demetrius Green.
All right.
Thank you, Judge. Mr. Green was in custody. We bonded out before we had a chance to have a good conversation. I've been asking for an adjournment so that we can connect with Mr. Green, try to figure out what to do in this case.
March 26, 2026, 9 a.m.
March, what day? What was?
Bond will continue.
What's the date, though?
Today or the date I adjourned it to?
The date that you adjourned it to?
March 26.
Okay,
2006.
I have I got a letter. See, the days got mixed up because they gave me a letter at the shelter, and I see Garwood on the 26th at 9.
You mean Judge Garwood?
Yes, sir.
Okay, so you need another day.
So is it March 26th?
All right, here's what I'm going to do. You got to see Judge Garwood on March 26th, right?
Yes, sir. Yes, sir.
Okay, so I'm going to adjourn these matters to April 2nd.
Okay, thank you, sir. I will be there and I will be present.
Okay, thank you, sir.
Thank you. I will be in touch with you, Mr. Feaster. Thank you, sir.
I'll be in touch with you. Court calls the case, People versus Thomas Vasher. All 4 cases.
Ready, Judge Torshell Feaster, Assistant.
Oh, no, I was going to wait.
Sorry, Judge. On behalf of Mr. Vasher, please state your name for the record.
Thomas Basher.
Yes, you may approach.
Thank you,
Hey,
Judge.
creeping up here. Hear what?
Can't call. You gotta follow court's orders.
That's, all right,
I called because I called her.
Yes. The court's ruling. They told you not to. Okay, sit tight. Ready, Judge.
all right. Seeking an adjournment of these.
Yes, Judge. Could we please have a couple of adjournment?
During this March 26, 2026, 9 a.m.
And you're invited to respond.
May.
Your Honor, at this point, I'm gonna be asking for the defendant's phone privileges and texting privileges to be revoked. I have 23 calls to the victim's number from this, and the latest call being yesterday. In these calls, the victim was mentioned by name, they talk about the charges that he had court today, so at this point, I'm gonna be asking for phone privileges and texting to be revoked.
Any response?
No, Judge.
Defendant's phone and text privilege hereby revoked pending here.
Thank you, Judge. We'll go get the call.
Yeah, I mean, here's a chat.
Okay, well, let's.
Okay, to me.
Court calls case, People versus Zariah Griffin Bills.
Your Honor, Raymond Cook for the people.
That's Public Defender Jay Bellinger on behalf of Ms. Griffin Bills. Ms. Griffin Bills, can you please state your name for the record? Always have.
Yeah.
All right. I have before me a plea form. Is that what we're doing today?
That is the plan, Your Honor.
All right. Plea form indicates that the defendant is going to be pleading count 2, added count 2 of assault and battery, the 93-day offense. On the plea to that charge, count 1 will be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is our understanding as well, Your Honor. Is that your understanding?
Yep.
Okay, have her sworn.
Okay. These about to give will be the true oath. So we got,
Yes.
state your name, please.
Sorry, Griffin.
Chairman, this is court's understanding you're gonna plead guilty to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to $500 fine plus court costs. You understand that? Understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th district.
Yes.
Don't want to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Signed in advice of right or had one cut or had one signed on your behalf. All right, do you have any questions regarding those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will? Yes. And because you believe that you're guilty of this offense? On dated December 1st, 2025, at the location of 114 East William Street, City of Ann Arbor, Washington County, State of Michigan. What'd you do on that date involving a Mr. McKeon that makes you think that you're guilty?
I got into an argument with him and he grabbed me and I hit him. Multiple times.
Pardon?
I got into an argument.
Grabbed you and then you hit him?
And you hit him multiple times,
Yes.
and that was a force that was greater than his?
No, but yes.
No, but what? Well,
I mean, yeah.
I don't know that I can accept it.
I understand, Your Honor.
So what do you want me to do?
Your Honor, I would ask that if you're willing to either pass this matter, so I might have an opportunity to speak with her, or give us a new date.
So your birthday?
It's St. Patrick's Day next week.
Your birthday?
It's,
Oh, it's Saint,
I'm Irish.
claiming the Irish saint.
I'm Irish.
Nope, won't work. I'll give you a new date. Probable cause conference. I'll adjourn this out to March 26, 2026, 9 a.m. All right.
All right, thank you.
Her bond will continue. Thank you. Laquita Thompson.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Thompson, who's now approaching. Can you please state your name for the record?
Laquita Thompson.
All right. What are we doing? You're seeking an adjournment?
Yes, I am seeking an adjournment, Your Honor. And I'm prepared to address the corrections report.
Pardon?
I said there was a note for community corrections reports. I'm prepared to address that.
And on February February 22nd, she blew numbers. We're at her 3 blows, then she took an EEG the next day. It came back.
Yes, Your Honor. In addressing the alleged violation, my client does indicate he does admit to drinking on that 22nd date. It was unfortunately she did lose a friend of 24 years, someone she worked for and has known for a very long time. And unfortunately, as part of the grieving process, she does admit she did have a moment of weakness and there was a mistake and she did drink. She is working very hard on maintaining the good strides she has made in her life. She currently works 2 jobs. one where she works approximately 12-hour shifts on her feet at a manufacturing factory. She has done community service. She attends AA meetings. I actually do have AA sign-in sheet I can provide to the court and the prosecution. She attends them both in person when she's able to, and on Zoom when her work schedule does not allow her to make in-person dates. I do want to note, prior to being placed on the prior to being placed on the sober link, she did have no violations on the scram tether. She had to be placed on the sober link due to issues with her ankle, and that was why at the previous PCC date you allowed her to switch over to the sober link. I do note I do understand there are several late tests. However, I do want to note several of those tests she did test within 10 minutes after the time frame occurred. I think 7 of those total. And for all of those late tests, she was negative. She does, as I indicated, work on a manufacturing line. So often, sometimes there are moments where she cannot physically step away from that line due to the ongoing working process, as it would be obviously a process issue for the process of work, but also for safety down the line. She has indicated that she has reached out to her supervising agent to discuss these matters when she does have a late test. She is actually working on obtaining a house and was actually supposed to assign on that house today. She is doing a lot of work to improve her life, continue doing what she must. And I think it is clear that she is attempting to do with everything within her power to comply with the bond conditions. So at this time, Your Honor, I would be requesting that she have a second chance and that her PR bond be maintained.
Any response to the people?
Right, Your Honor, is that we kind of was on a tether and we agreed to change her to a sober link. Now she has these issues.
Yep.
And it was right about immigration system, the court to modify those conditions. So, here as I can see, there's an option.
What's that option? Lock me up.
I will adjourn the probable cause conference to March 19, 2026, 9 a.m. Defendants bond this time, having it filed.
My God,
Both defendants remanded.
I have 2 jobs. I have 2 jobs. I got, oh my God.
Want me? Court does call the case. People versus Benny Sims Jr.
Assistant Public Defender Davy Lebo for Mr. Sims. Mr. Sims, could you take your hands at your backs until the court time?
Miss Benny Allen Sims Jr.
All right. And he's waiving.
Yes, no, we reached an agreement for a resolution in circuit court.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's proceeding where the people would have to show by probable cause that the offense alleged was committed in which you committed it?
Yes, sir.
You understand you'll not have that hearing? You'll proceed to circuit court for further resolution?
Yes, sir.
You will also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information. We waive formal reading, stand mute, and ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for May 4th, 2026, 1:30.
Thank you.
For Judge Hamoud.
Thank you, Your Honor.
And bond in this matter will continue. And Mr. Sims, thank you for coming back.
Thank you.
Oh, know that you showed up bright and early, right? We realized that you weren't in the right, well, you were here early.
Yeah, I'm trying to stay up out there, stay up out of jail, man. I'm doing good. I'm
trying to stay out of jail.
Yeah.
So you know what?
Going back, I ain't going.
So I sent Mr. Allen out to tell Mr. Sims that he didn't need to be there till 12:30, so he came back out.
Sir.
You remember what you said?
Well, which one? Her right there?
No. Do you remember what you said to Mr. Allen?
Oh, I said, can I go outside and
he said, oh, cool. He
me-
said, I'm gonna go outside. Yeah, okay. All right.
Thank you.
All right, fella. You take care.
Y'all too.
Court calls the case. People versus Laura Smith.
Michael Gaddy, assistant. Miss Smith. Just approaching judge. State your name.
Laura Smith.
You're requesting an adjournment.
Yes, Your Honor. Ms. Smith is seeking, I believe she will be assessed and hopefully admitted to the Saginaw Treatment Court, Saginaw County Treatment Court next week on the 17th, and then the 19th, I think, is the
My
she has,
appointment date.
yeah, her appointment dates. We did submit some testing documentation to the courts. I was able to contact TRICAP and get those dates.
Okay, all right, she's good. So basically, the 3 and 3/9, she did have testing. What happened in February?
I was on the SCRAM program in Saginaw, and I was seeing my probation officer weekly. And she wasn't testing me then. She was just reading my SCRAM teller. And I didn't find out until I was getting it taken off of me where to go to actually be tested.
Got it. Okay. I'm not gonna find it.
Well, they're
Shocking, I will.
oh, I'm sorry.
All right. So you're seeking an adjournment?
Yes, Your Honor.
Now, you said you're hoping to get her into, how long is that gonna take to try her lined up for that program?
Well, she's already, I think the way it works there, she's already on probation and she has to pay the assessment fee and do the screening, and she's scheduled to do that next Thursday. So the 19th.
Then that it leads into.
Yes.
Got it. Probable cause conference, I'll adjourn this out to April 2nd, 2026. 9 a.m. Bond will continue.
Thank you.
You're welcome.
Hold on just a second.
Court cause case people versus Matthew Smith. Are you looking at that?
Assistant Public Defender Davi Lebo for Mr. Smith, who appears on Zoom.
Matthew Smith.
Thank you.
In regard to requesting adjournment, I have not been able to get into contact with Mr. Smith. I would ask Mr. Smith to please contact the Public Defender's Office at the soonest opportunity.
Probable cause conference will be adjourned April 2nd, 2026, 9 a.m. Mr. Smith, do you have the Public Defender's Office number?
Yeah, I emailed them and I had them. I talked to them. I was told my attorney was Miss Gaines.
Okay. So you spoke with Miss Gaines?
Yes, sir. Yesterday, as well as the day before, I ended up coming to
That's okay.
residential treatment, and I had them fax her the paperwork or email it to her, as well as my agent, Miss Dozier, and I spoke to both of the paralegals at the Public Defender's Office. They're the ones who gave me the meeting and ID for the Zoom meeting today. I don't know where communication is going bad.
Very good. I'll adjourn it out to the 2nd of April, 9 a.m. Bond will continue. All right, sir. Thank you.
Thank you.
Court calls case people versus Michael McClure.
I missed the whole thing. I stated my name. He's like,
Oh, no, I want to hear what she said. Missed the whole thing.
my client, she also.
Yeah, that was your client experience. She missed the whole thing, but I think what she missed was the bench conference because she was closed out. So I think that was what she was thinking. Go ahead.
Good afternoon, Your Honor. Joseph Hall, appearing for and on behalf of Mr. McClure, who stands to my right. Michael McClure.
Thank you.
Thank you.
Where's Vincent?
I got him out of here as soon as I could. I mean, one of us in the room at one time is enough.
Again, he sent Vincent out. Vincent's lost. I had to get through your hearing. I have to go find him. All right.
I've done worse on a day. Your Honor, in this case, I believe Mr. Chebolowski just sent me what was a transcript for a dispatch recording that I don't even believe is going to be relevant to this case overall, but I believe that completes discovery, and we would ask this court to set a preliminary examination.
All right. And would the people have their witnesses available on the 24th? All right. Preliminary examination in person will be set March 24th. 2026, 9 a.m. before judge. For me.
Perfect date, Judge, as always.
Okay. All right,
Take care, Your Honor. See you later.
go find him. Drive himself.
I'll do my best.
Drive himself.
Yeah. I'm more trusting than Amanda Nelly.
That'd be like parking lot of bumper cars. Get out there and find him.
That's why you park in the back, right, Judge?
Hurry up. The People versus Jeremy Shue.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Shue, who is
there.
coming right over.
I was expecting to see him on
Introduce yourself. Jeremy Shue.
I know Mr. Shue.
Thank you.
Had our moment. All right.
Denied the Zoom hearing. Yeah, all good and getting better, Your Honor. Mr. Shue is here in person. I wanted to ask the court to consider a motion to stay. We're in the same holding pattern that we have been. He has a pro per interlocutory appeal on a companion case, and that companion case involves the same series of episodes and the same car stop that is the subject of his interlocutory appeal. Last time we were here, Your Honor continued it rather than staying it just to see what would continue to happen in the Court of Appeals. What has happened is they dismissed on administrative grounds. Mr. Shue filed a successful motion for reconsideration. They've now, because it was just an administrative dismissal, it never got to the merits. They've now reopened it, and it's continues to be on a leave application.
Okay.
And rather than come back every few weeks, we're asking the.
So I guess I'm a bit confused. I'm a bit, I won't say confused, but I'm want to make sure I have an understanding of how the decision in that appeal affects this case.
Sure. So there are a series of alleged episodes that took place in a neighborhood, some items that were allegedly taken. And the first case is a misdemeanor case in Judge Washington's courtroom involving the first set of items that were potentially recovered in a car stop, or at least items that might look like those items. This arrest came many months later, involving another house in that same neighborhood in that same period of time, and also involving things that were found in that car stop. So if that is a bad car stop, then that impacts this case as well.
I see. So it's really, I see what you're saying. Do the people have a position?
We'll leave it up to discretion of the court.
Pardon?
I would leave it up to discretion of the court on objection.
Here, so my other issue with granting a stay, which is, I mean, I get why you would want that to happen, but are you asking in essence for an order similar to that was signed by Judge Washington?
That's right, an identical order, and I'll keep the court up to speed as things develop in the Court of Appeals.
All right.
She set a status date for a few weeks from now.
Status date for March 26th, but I wouldn't do that. And how, I'm just thinking timing wise, I'm not sure how fast or slow the Court of Appeals is operating at this point.
Yeah, I mean, I have to be honest, I'm really surprised that it's taken this long, but and I may have been because of the initial administrative denial, but it doesn't seem to be moving anytime soon on this.
All right, what I'll do is I'll order it stayed with the next court date being, I'll just go a month out from there, April 23rd. (2026) for status. And then I'll just adjourn. Well, the way we'll have to do it here. since it's not my misdemeanor or my district court docket technically, is I'll have to give the probable cause conference that date.
Okay.
Okay. Effectively kind of a stay, but
No, that works, Your Honor, and I'll be in touch with your staff and with Assistant Prosecutor Childers as their developments and in advance of that date, if it's still in limbo.
yeah, if it's still in limbo, and so that I'll state this on the record, my staff will remember this. If we still don't have a resolution, now that I can appreciate what you're saying in terms of the case itself, I'm not gonna have a problem adjourning it by stipulation.
Okay.
Say a month out, so we'll just see where we are.
Great. Thank you, Your Honor.
All right, thank you.
Next time.
Court calls case People versus Demetrius Caldwell.
Jablowski.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Caldwell. Your Honor, Mr. Caldwell is in the Washtenaw County Jail. Your Honor, we're just seeking an adjournment. This was scheduled today for competency hearing. I have not received a report as of yet, but I did have correspondence with the doctor who was doing that interview Monday of this week. So I think that is coming sooner rather than later.
Got it. They didn't say when he would have the report. They just said when the appointment was, right?
Correct.
Okay.
Dr. Oliver didn't give me any indication, just that, I was glad to have heard from her in the first place because that lets me know that, he's either spoken with him or was going to be speaking with him relatively soon.
I'll adjourn it to April 16th, 2026 at 9 a.m. for a competency hearing. If we get the report prior to that point, we can move up the day.
Perfect. Thank you so much, Judge.
Yep.
Thanks. Judge, that's it for me today. I've been on every docket with you today.
Absolutely. I was gonna say, we're gonna miss you because right now, right? All right. Take care of yourself.
You too, Judge. Bye.
Bye-bye.
Thank you.
All right, appearances
Thank you,
on
Tony.
Wallace, please.
Jerry Davis, Lafayette, Pete, versus Southern Florida, about John Wallace. Stands.
All right. Thank you. All right. What do we got today?
Motion to suppress, Your Honor. Let's go with Carter, response.
I don't know that I've seen the response. I don't think I've seen it, and it's not in the file. Do you have a copy? Let me have it. If you guys just give me a few minutes. Yeah, it's short. Let me go through that and then we'll talk. Okay. All right, ready for argument. And you guys don't have to jump up.
Your Honor, in this case, just briefly, my client was stopped, walking down Will Carl. The police came upon him because of 2 911 calls. One is suspicious because it came from my client's own phone, from a distance away from someone else's house. The second one is a valid 911 call. It's credible because the caller gave his first and last name. Said saw someone walk down the road, looked intoxicated and stuff. Where they using a phone. Neither of these calls put my client behind the wheel of the car. The first one says there's a car in a ditch and there's someone on one road and there's someone walked down another. The police come, they talk to Mr. Wallace, and he makes some statements that that's what ends up getting charged with operating while intoxicated. He was never Mirandized, but even if he was, it doesn't really matter. The statement by Mr. Wallace made during his interrogation are in Ms. Wallace and voluntarily, knowingly, and intelligently waived his right to self-incrimination. They must have been made with full awareness of both the nature and the right being abandoned and the consequences of the decision to abandon. The people quote Bergamo and Oregon as stating that the police don't have to Mirandise people on traffic stops. understand that argument. I've made it myself before. The difference here is that the people completely ignore Cipriano and Stewart. And Cipriano, there's 11 factors looking at whether or not the statement was knowingly made. The age of the.
Well, that's two different issues though. First is, should they have Mirandized him? And your argument is Miranda or not,
Miranda.
statements aren't usable. Yeah, so let's not mix those two arguments. Right, let's talk about first one first. Let's talk about whether or not they should Mirandize him. Unless you want to just skip that one.
I'll skip that one because I think Burton and Oregon control on traffic. So
Okay.
Say this is a traffic stop. They were walking down the street. It's more akin to a Terry stop than a traffic stop. But even if he wasn't Mirandized, I think Cipriano and Stewart control that, because Cipriano looks at whether or not constitutional advice would render whether the person was Mirandized. It's one of the factors, and none of the 11 factors control in and of themselves. Cipriano looks at the totality of the circumstances. So they look at all of the factors together, along with everything else. So whether or not he was Mirandized, I don't think is the issue here. It's to allow you to suppress the statements.
All right, then let's talk about the other factors.
In Cipriano, the control are the age of the defendant, the extent of the prior police contact defendant has had, lack of constitutional advice, injury, intoxication, or ill health of the defendant, and private food, sleep, or medical assistance. My client Mr. Walsh was 22 days away from his 21st birthday on the date of the stop. Stewart was an 18-year-old. There's not a lot of difference between a 20-year-old and an 18-year-old, I believe. He was young. He didn't know because he's not development's in brain, not complete yet. He's not a juvenile, but he's not an adult. Fully formed. He hasn't had any prior police contact. He's not aware of his rights completely. He wasn't Mirandized. He was highly intoxicated. And he was potentially in an accident. He did ask for medical care. He was taken to the hospital. The blood draw that came back was 0.25. It's exceedingly high. It's 3 times the legal limit to draw. I find it difficult to believe that you can say you're too intoxicated, but yet we're going to take every statement you say against your own self-interest as the main. When you you take all of that and you add in the facts of the first 911 call, I included an affidavit in compliance and other. The people say they don't understand the reasoning for that. The reasoning for that is Ms. Wallace, when retrieved Mr. Wallace's phone that day from this other individual, Mr. Cipriano, who I believe made the phone call. I believe the phone call was made from that phone for 2 reasons. One, there's a screenshot of my client's phone saying it was used to call 911 at 11:40 on August 2nd. And 2, when you listen to the 911 call, the individual who says his name is Brandon is talking to the 911 saying that there's a car in a ditch. It's a 300 Chrysler, it's black, and there's someone walking down Will Carlton Road. While he's making that phone call, while he's making that 911 call, an automated message from Mr. Wallace's iPhone breaks in and says, the owner of this iPhone has been involved in a serious car accident. They're not responding, and they give GPS coordinates. And those GPS coordinates just happen to be Mr. Spina's house. So there was another person in the car. It's entirely possible that Mr. Spina was the driver, put the car in the ditch, and took off with my client's phone, and he made this phone call at a later time. That's reasonable doubt for a trial, I understand that, but when you look at that and you put it all together, there is reason to doubt my client's statement because of his level of intoxication, because someone else was there and was potentially driving, because no one saw my client driving. I believe these statements should be suppressed. I believe that they're not credible based. And without these statements, there's no one to put it. Mr. Wallace operating the vehicle.
Anything else at this time?
No, Your Honor.
Madam Prosecutor?
Statements such as I parked it there, I just sat there and I figured I would just walk the rest of the way and get it towed. I ain't going to bullshit you. I am obviously way too intoxicated to drive, and that's why I stopped. Defense wants us to believe the defendant was still undergoing physiological and neurological maturation, was unable to fully understand or appreciate the situation and the statements that he had made. If we were to apply this standard, then all men in their late teens and early 20s would be given a pass to commit crime up until their prefrontal cortex had fully developed. Defendants made multiple decisions that day. He made a decision to drive drunk. He made a decision to make these statements. He made decisions such as electing not to complete field sobriety tests. He made decisions not to, when asked where he got the alcohol, he told police that he didn't want to tell them. He made decisions such as when they asked what friend's house he was heading to, he elected not to tell them. He made all of these decisions that day. I find it hard to believe that he can make all of these well-informed decisions if he wasn't able to fully understand those statements, such as I parked it there, I drove, all this other statements that he made as it relates to driving the vehicle, but can't appreciate the statements such as not giving consent to do field sobriety system or a PT or anything of that nature. He also told police that he knew his laws. He told police that he came from a background of law enforcement officers who was making very clearly informed decisions based upon the situation.
Respond.
Yes, Your Honor. One, I don't believe that you can take one instance, this case in particular, and paint everyone's getting a free pass for committing crimes because they're not over 25. That's not the point. My point is fully looking at his age. It's one instance. It's of the Cipriano factors that goes towards the entirety. So we're not saying that everyone gets a free pass because they're not fully formed yet. That's a broad generalization of people, not our point. Again, age being one factor, the level of intoxication being one factor. You could have said he killed a defendant, it doesn't. So I think that everything needs to be looked at much more closely and not just cherry picked. Oh, he said he was drinking driving, so obviously he wasn't. When there's no other corroborating surface, no other corroborating evidence whatsoever, not even the 2 911 calls put him in the vehicle. That I saw a guy put his car in a ditch and now walking down the little car. That would at least be some circumstantial evidence that he was operating the vehicle. People also raised the fact that the car was tied to his mother, that one of his credit cards was his car, and that he had the key fob in his pocket. So, obviously he was driving. Having a key fob for a new model car doesn't mean that you're operating. It means you could be sitting in the passenger seat and someone could push the start button, the car starts. You could be next to the car and someone pushes the start button and it starts flipping, you're operating. Looking at everything, again, looking at the totality of the circumstances, including the suspicious 911 call. I believe causes a credibility issue with the statement of a 20-year-old who had a 0.25 BAC.
Anything else? Let's talk specifically about Cipriano and how it applies to these facts.
So let's see. So the age of the accused, the defendant was a couple of age shy of 20 years old. The one by the prisoner, intelligence level, I understand now when he told the police, he explained that he had a lucrative career as some sort of murderer, content with her, what have you. He obviously knew, he told police that he understood that, he could not drink. He understood that he should not drive when he was intoxicated. He had knowledge and wherewithal to know that these things were wrong. The extent of his previous experience with the police, I know that he had no priors, so I have no reason to believe that he knew, but he didn't know they were police, they were fully uniformed and what would identify themselves as police officers. Going to the detention of the accused before he gave the statements in question, he almost immediately stated that the party was illegal. He went on to say all these other statements just within the first couple of minutes of interaction with the police. The lack of any advice to the accused of his constitutional rights. Again, he knew that, he told the officer that he knew his laws, that he had police background or to his family. He made decisions such as not doing the PPT, not doing field sobriety.
How's all that fit Cipriano though? The fact that he made decisions, how's that fit Cipriano? I understand his statements that he knows law enforcement, he knows cops, whatever, I know my rights, whatever that is. I understand how that would fit to his educational level. But how does all this other stuff you're giving me fit Cipriano? Having made other decisions?
I mean, well, there was, I'm sorry, the lack of any advice to the accused of his constitutional rights. Because he knew that, he stated that he knew the laws.
Right.
Knowing the laws, he knows that he can say no to certain things, such as the PPT and those crimes.
Okay. Anything else you want to say about Cipriano?
I think those would remain factors if you wish.
If you think they help you.
I guess we can start where, whether the accused was injured, intoxicated, or drugged and in ill health when he gave the statement. He did have a very, very, very high case. Was intoxicated, but frequently in the other case, people are intoxicated. That is probably 15% of traffic stops are drunk driving. In order to investigate drunk driving, you have to ask questions of the individual. He did tell the officer that he needed some sort of medical intervention about half an hour into the investigation. Officer Nally immediately called for assistance. Officer Diosecki was on scene. He is a trained and certified EMT. The defendant could not articulate what was wrong with him other than not feeling well. I think that would be the last one.
Okay. All right. Anything else?
Yes, you are. I understand that, the voluntary injection of alcohol and substances, alcohol and drugs isn't, a defense between both. We're not talking about whether the crime was committed here. We're talking about the statements that were made that will link my client to these charges. And again, I think it bears repeating. A 20-year-old with 0.25 alcohol beyond and underage drinking, everything else goes along with it. I think looking at taking that into consideration with his statements, who knows what he's saying is true, and there's no other corroborating evidence to put him behind the vehicle operating. All you have is these drunken statements with no other proof. With that, I believe statements can't be looked at as credible.
Anything else? Anything else?
No.
All right. It's a close call, counsel, but I'm going to deny your motion. I encourage you to appeal it. Anything else?
No.
Good luck. Delaware.
Ready, Your Honor. Good morning, Your Honor.
Good morning.
Record Jeff about it, 45367, appearing on behalf of the Mr. Law. Sir, could you tell the gentleman to make it correct, please?
Thank you.
Your Honor, it's been a big concept for bringing in this matter in great form of readings. Also, I had a chance to pre-trial it. Prosecution, I've been with Mr. Delauder. We have executed plea agreement where Mr. Delauder would be in the one count of having a dog at large.
Good.
There is a little caveat in there that the prosecutor wished that he agreed upon. He has to get his dog in some sort of training program within 14 days and provide proof to the court. If so, the matter would be taken under 771 for a period of 12 months. The other charge, Your Honor, would be dismissed.
Okay. Mr. Delauder, you understand your rights and options after discussing those with Mr. Bowditch?
Yeah.
You understand the possible penalty for dog at large?
Yeah.
Are you pleading guilty freely and voluntarily, understanding all that? Did you have a dog at large on 12/7/25 in Huron Township?
Yes.
Satisfied?
Satisfied, Your Honor.
Satisfied. I'll dismiss the companion case.
Thank you.
No prior criminal offenses?
No, Your Honor.
Working?
No.
How old are you?
20.
How come you're not working?
Then how to find a job.
Bullshit. How come you're not working?
Well-
You got transportation?
No, not really.
You got a driver's license? Why not?
Because I can't pass the test.
Where'd you go to high school at?
Black High School.
Finish? What have you done since then?
I've been trying to get my license, trying to find a job and.
Dude, don't give me that. Don't give me that. Everybody I know is hiring labor. Everybody I know is hiring labor. I know a guy that owns 6 subways and he's working the line every day because he can't find people to work the subways. I know guys in the construction trade that are turning jobs down because they can't find somebody that'll show up and just do the backbreaking labor that it takes to do construction work. I'm putting you in jail if you don't have a job next time I see you. Clear?
Yeah.
Okay. So we'll set a sentencing date. Give me a date at least 2 weeks out. When you come for sentencing, bring documentation of the training.
March 26th.
March 26th, how's that work? What time?
9 o'clock.
9 o'clock. All right, if you want some help finding a job, on the way out the door, go down and talk to Mr. Taylor downstairs, best dressed guy in the building. He'll give you some options locally that people are always hiring. But hear me, on the 26th, if you don't have a job, bring a toothbrush.
Okay.
Okay.
Wait for a notice.
Range files judged. Thank you. Thank you. All right. Have a seat.
Just so that I can make sure that.
Schomer?
Your Honor, Tyler, people 75702 on behalf of Mr. Schomer, who's staying to my left. Mr. Schomer, can I say your name for the record?
It's Kenneth Schomer.
That's
CH.
Counsel, you want to adjourn the case ending in 386 A, B, and C?
Yes, sir, and that's not necessarily an adjournment, we're asking for a trial date for the 5-2 trial.
2 different things in my courtroom.
We're asking for a trial date, I don't know if this court sets final pre-trials.
Why do you want a final pretrial?
I guess.
You're not getting. This guy's been in the system long enough. What kind of trial you want?
Can you get Caitlin in here just so, or tell her to jump on Zoom if she needs to, I need to work on dates.
All right, so I think I got A, B, C. All right, those are the files we're gonna set for trial. All right, he's got some other files he's got warrants on. Are you aware of that? All right.
Is that for the probation, Your Honor?
Yeah, he's got 2 files that he hasn't done a damn thing I've told him to do.
He's told me that he's completed all of the probation requirements, however.
Then you might want to talk to, you don't want to talk in front of me. You might want to talk to probation because I'm getting ready to put him in jail for 6 months.
Okay. Thank you, Your Honor.
I'll let you hold the files until you talk to probation. Because based on the information I've got, he hasn't done a thing I've told him to do. Yep. Counsel, we'll call probation, ask her to come up. Miss Belcher, do you have a preference who we start with?
Dealer's choice.
I've got Austin, Kitchens on top.
Okay.
Good morning, Romulus. Can we have Kitchens up?
Want to stand up?
Miss Belcher, would you waive formal reading for Mr. Kitchens?
Yes, Your Honor, and stand mute to the charges.
Thank you. We're going to set up a pre-conference PCC March 24. That's going to be with me. That'll be live. Right? We're doing live. PCC. Yeah. All right, let's talk bond. Did you see the bond rec from the department?
Yes, Your Honor, I did, and I did review that with my client.
All right, where's he on probation or parole at? They didn't give me that.
Your Honor, my understanding is that's HIDA probation out of circuit court. Is that
All right.
correct, Mr. Kitchens?
Yes, I just got it yesterday.
Oh, you just got sentenced yesterday?
Yes, Your Honor. I went to go get my tether taken off, and that's when they told me I had a warrant from out here.
Okay, so as far as you know, you're in compliance with HIDA other than what happens on this charge.
Correct.
You've done nothing else to violate your probation in circuit court, yes or no?
No, Your Honor.
That you know of? Okay.
Not at all.
Okay, are you working?
Yes, Your Honor.
Where do you work?
I work at Jan Door in Dearborn. I put doors together.
Yeah, I know Jan. How long you been with Jan Door?
I just got laid off from the laborers union. I was in local 1191. I was working for Rudolph Libby. They laid us off during the winter. So I just started Jan Door last week because I needed something because I have a 8-month-old daughter I'm trying to take care of.
All right, so how long you been in the union?
I was in the union for about a year.
Okay. What else should I consider, Miss Belcher?
Your Honor, he's 24 years old. The complaining witness, my understanding is that's an uncle. The address that's listed is not an address that the uncle resides at, so he would have no reason to have contact with him if Your Honor released him on a personal bond. It's a bit strange to me, Your Honor, that this warrant wasn't caught before he entered a plea because they could have done a global resolution for him. So he's in a bit of a bad spot just because things weren't caught in time. From my understanding,
I'm sorry, the circuit court case he's on probation, was that out of our court?
I don't know that it's out of your court, Your Honor. I know it's Wayne County.
He says no. Okay. All right. Anything else?
I believe it's the same prosecutor's office, so that's why it's strange to me.
Yeah.
He was in compliance with his tether before. He says he has no capious history. I know he has ties to the community. There's certainly conditions Your Honor can put in place to protect the complaining witness, such as no contact. For all of those reasons, Your Honor, I would ask that you consider a personal bond.
Yeah, I can consider it. All right, Mr. Kitchens, I'm going to put you on a personal bond. First two conditions are pretty obvious. Stay out of trouble and show up for your court dates. As I said, your first court date with us is March 24. We'll do that at 9:45 in the morning. That's live, my courtroom. We're also going to set a preliminary exam for March 31, my courtroom, 9:30, also live. Additional condition is that you have no contact with your uncle. That means no phone calls, no letters, no social media contact. He tracks you down and says, hey, bud, let's get together and have a cup of coffee. No, he doesn't change the order. Only myself or another judge with a black robe. You run into him at Taco Bell, you're at Burger King. He does not exist to you until somebody tells you you can have contact with him. Clear?
Yes, Your Honor.
All right, raise your right hand. Swear or affirm and acknowledge the debt payable to the court in the amount of $5,000 if you mess this up.
Yes, Your Honor.
Any questions from me or Ms. Belcher before we terminate the meeting?
Not currently, Your Honor. Thank you.
All right. Good luck.
Thank you, Your Honor.
Thank you, Your Honor.
Romulus, do you have Donald Laramie there as well?
That's correct.
All right. Ms. Belcher, your appearance for Mr. Laramie.
Good morning again, Your Honor. Leanna Belcher on behalf of Mr. Laramie. Sir, will you please state your name for the record?
Donald Laramie.
Thank you. All right, we've got a couple different files for Mr. Laramie. Let's start with the July 30, 2024 B&E out of a vehicle out of Romulus. Would you waive formal?
Yes, Your Honor, and stand mute to the charges requesting a probable cause conference date.
Done. That probable cause conference is March 24 with me. We'll set a preliminary exam for March 31 with me. Let's talk bond for Mr. Laramie.
Yes, Your Honor. He's 35 years old. The address on the paperwork is a good address for him in Novi. He did indicate that he is employed full-time. He works as the GM at Powerhouse, and he also works on the weekends doing personal training. He has a 4-year-old son that lives in his home. His significant other is out of town for a month, so he is concerned. The aunt does have the 4-year-old son, but he is nonverbal, so it's imperative, Your Honor, that he get back to take care of his child. He indicated that his warrants are out of some district courts. Some of it's just a financial obligation, Your Honor, that he owes money for a probation violation out of Plymouth. These offenses, or this specific one, occurred in 2024, so there's been significant time since then. And he did indicate, Your Honor, that he's been sober for 2.5 years, so he's certainly turned his life around. I would request, Your Honor, impose a personal bond.
Thank you.
Okay. All right. So, Mr. Laramie, I've got 2 other files. We're going to talk about dates on those.
Okay.
That you missed court dates back on, well, it looks like early January 25, so a year ago. It looks like at that time your address was on Kensington.
I never lived on Kensington. That was a mailing address, and the person never got my mail to me, so I apologize about that. I never knew about it. If I did, I would.
All right, so that the reason you didn't show up for the court dates is because you didn't know you had court dates?
100%, sir.
All right, brother, I'm going to give you a chance on a personal bond. Don't screw this up, because if you screw up, you're screwing up in front of me. I won't forget.
I appreciate you. Thank you, sir.
All right. All right, so on the felony file, 9:45 on March 24 is your first date.
Okay.
9:30 on March 31 is your second date.
Okay.
First 2 conditions on your bond are the obvious ones: stay out of trouble and show up for court.
Yes, sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $5,000 if you screw that up?
Yes, sir.
Any questions so far?
No, sir.
All right, put your hand down just for a second. I've got a 9/20/2024 Van Buren misdemeanor charge, 2 counts. Would you waive formal reading on that one, Ms. Belcher?
Yes, Your Honor, and stand mute.
Thank you. I'll enter not guilty plea. Pretrial is going to be with Judge Martin on March 26, 10:50 in the morning. That's Zoom, Mr. Laramie. Understood?
Yes, sir. I'll get printouts of all this, correct, Your Honor?
If the officer is nice enough at the department to write it all
Thank
down.
you. I appreciate it. Yeah, get a copy. Thank you.
Thank you. All right, I'm going to put you on a personal bond on that one, Mr. Laramie.
Thank you.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 on this one if you miss your court date?
Yes, sir.
Put your hand down. Last file I've got is a Romulus misdemeanor. January 8, 2024 is the incident date. April 2, 2026, 8:15 in the morning, live with me is your pretrial date. I'll put you on a personal bond on that one. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 on that file if you screw up by not showing up?
Yes, sir.
Any questions for Ms. Belcher or myself?
No, sir.
You're all set.
Thank you, Your
Thank you,
Honor.
Romulus. Stay
Thank you, Your
safe.
Honor. Thank you.
And Ms. Belcher, who do we have in Wayne County?
Your Honor, I didn't receive any additional files for arraignments.
Judge,
Okay.
it's Ackman,
Ackman?
and he
Okay.
did not. He's shaking his head no, but that's the paperwork I received from the county.
All right, Mr. Ackman, can you hit the mute button there so I can talk to you? Well, so you can talk to me? Can you hear me all right?
She said I'm shaking my head. What I'm shaking, I don't know what's going on.
Well, that's all right.
Good
That's why I
morning,
wanted to talk to you, so I can try to
good morning,
explain you.
Judge Oakley. I ain't disrespectful. Good morning, sir.
All right, good morning. All right, do you want to talk to a court-appointed attorney for arraignment purposes? or
Ain't
do you wanna
nobody
waive
talked
the
to me
attorney?
about nothing. I just got yanked out at the last
Brother,
minute. I
that's
don't
why
even know
I'm
what's
talking
going
to you.
on
I'm
today.
telling you now. I'm telling you now.
Yes, sir.
Judge,
Trust
can you,
me.
Judge,
I
can you
want you to
confirm the
understand
name?
what's going on. Do you want to talk to an attorney before I arraign you?
Yeah, I need to know what's going on. I don't even know nothing about this.
Judge,
You
can
know
you
the
confirm his name?
Yeah. Are you Terry Ackman?
No, I'm Javon Edwards.
I did get
Edwards.
paperwork on him.
I'm Brooke Edwards'
Okay.
grandson.
All right, we don't even have any paperwork on you, so we don't even know why they put you in that hole. So tell the deputy, we don't have any paperwork on you yet.
God bless you, Mr.
They
Oakley,
might have
man.
you in front of the wrong camera right now. I don't know.
I don't know either, brother. God
All right.
bless you, man.
Good luck.
Yes,
So
sir.
what's going on with Ackman? Mr. Bout, it's your appearance for Mr. Schomer.
Your Honor, for the records, Jeff, about carrying out. With Mr. Stover, sir, you tell the judge your name for the record, please. And it's Sean.
Thank you. Hold on just a minute. just so you know, we told Mr. Smith, we'll just give him a notice.
Yeah, like,
We'll let you know what the date is.
I think I
Okay.
got it right up right here from Mr. Smith.
Yeah.
I don't know why there's two.
Oh, no. It's just an adjournment.
Yeah, adjourn for discovery.
Gonna be in person, just so you know, remember? You did a sentencing, Mr. Louder, we changed to.
Yeah, DeLauder is not a pretrial day.
That's fine.
Yeah, so this will be a different date.
Absolutely.
Okay, all right.
Your Honor, today's the date, it's set for violation of probation.
I've got two files. I've got a file ending in 1182, and I've got file ending in 1648.
Your Honor, the violation of probation is he picked up new charges. I'm not addressing the new charges because he has a retained attorney.
Right,
on the New charges.
and a date to come back on that file.
Right.
Right.
But he has an issue today, Your Honor.
So that's not the only issue today. The new charges are an allegation that they would be a violation of probation, but my indication from the probation department is that Mr. Schomer has not done anything I've told him to do. Told him to do treatment at GrowthWorks, told him to do community service, gave him work program days. Has he ever showed you any indication of treatment?
No indication or documentation of treatment, Your Honor. He did complete his 30 hours of community service, which was a sanction for appearing at the court intoxicated.
Right.
And a documentation of treatment. He did complete the order of 10 days on the work program. Again, that's a sanction. Completed 8 or 9, I believe, and on that 8 or 9th day was when he was intoxicated while on work.
Right. So he hasn't finished the work program. He showed up here, including today, at least 3 times under the influence. What was his PBT today?
Today is 0.10.
All right. Do you have, Mr. Bowditch, do you have any concerns whether or not Mr. Schomer is so intoxicated that he can't make informed decisions today? All right. So are we entering a responsible or a guilty plea to the violation or a not guilty plea?
Well, Your Honor, I said he's guilty. He picked up a new charge and he's intoxicated in court. That's obviously a violation. So we be pleading guilty. He said his explanation, he can afford that to you, Your Honor.
I'm willing to listen to anything you've got to tell me, Mr. Schomer.
Excuse.
It was last night, I had girls and friends come over, we were playing cards till like 2 o'clock in the morning. And I went to bed after that. I didn't wake up this morning to sign anything. Right? I came in here, took a shower, had my coffee, and I showed up here early.
All right.
To tend to, a case, that they think I was drunk, and there's no proven evidence of that.
Well, I'm not talking about that file. That's,
Okay.
you've got to,
I was here this morning.
yeah. Yeah, but you knew you were coming here. It wasn't a surprise visit.
Yeah, I didn't come in here intoxicated.
You're legally intoxicated by law, sir, don't argue. By law, you're legally intoxicated. The state of Michigan says at a 0.08, you are presumed to be intoxicated.
Come in here. I had a night, okay, with friends, okay, we enjoyed our moment, okay. I had a few drinks, okay, I can't.
Now, sir, don't blow smoke up my ass. Listen to me. If you're at a 0.08 at 11 o'clock in the morning, you had more than a few drinks last night. And you had more than a few.
I mean, I'm just enjoying the moment.
I bet you'll be counting now because I'm violating on both these files and you're going to do 90 days in jail on each file. I don't understand how your head works.
Listen, I can get Uber to take.
No, I'll provide transportation for the next trip. 90 days in jail on each of these 2 files, and then we'll close them out unsuccessfully.
I'll look at my own.
That's not my concern.
It's my job.
That's not my concern. Sir, I have given you every leeway.
I didn't do this intentionally.
You accidentally got so drunk last night that you're at a 0.10 at 11 a.m.
I felt.
Then grow the hell up. You're not 20 years old. The kind of behavior I'm seeing from you is what I'm used to seeing in 20-year-olds. Go to jail. Goodbye. We're done.
What do you want this way? You think we're my pets? Are they here now? No. Okay, we got.
Thank you.
Never ceases to be baffled. You know? All right, thank you, Mr. Bowditch. It must. We were talking about it. He's always the most pleasant of people, and he keeps making decisions like a young and dumb.
Is sober for 180 days.
And he'll get drunk when he gets out.
You lose control of that.
Absolutely. Absolutely.
Yeah, we take it.
But now, you know, all this stuff, it's stupid, but it's not dangerous. But now the allegation is he's driving like that. Right? I mean, we can't. He's gone beyond, he's a nuisance. Right? Now he's a danger.
Thank you.
The only good news, Your Honor, ain't one of my kids.
Good point. You're welcome.
Okay, thank you, guys.
We're on the record in the matter of the state of Michigan versus Jeffrey Campbell, 26286. Good afternoon. I'm sorry, do you need a few more moments to speak to your client? I'm sorry.
Good afternoon, Carly Kavanaugh, Phoebe, since one on behalf of Mr. Jeffrey Campbell.
Thank you.
Please state your name.
Mr. Campbell, you need to unmute, please.
Jeffrey Campbell.
Thank you. Today is the date scheduled for the probable cause conference in this matter. And counsel?
Thank you, Your Honor. We did get discovery in this matter. I went over it, spoken to my client. There has been an offer tendered in this matter, Your Honor, so the client is hoping to take that today.
Sir, please raise your right hand. You solemnly swear from testimony about to give in this matter, be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, and sir, you heard the counsel, did you put the basis of the plea?
I did not. And if you could plead to a reduced count of use of cocaine, Your Honor, which is a misdemeanor. The original count would be dismissed.
All right, and so sir, you've heard the plea that's been placed on the record, correct?
Yes.
And as to the amended charge of controlled substance use, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
I'm sorry,
Any immigration issues?
no.
All right, counsel, if you can please bring your client.
Yes, Your Honor. And Your Honor, I apologize. I'm just looking at my phone for the police report. I just did not have a.
Okay, thank you.
So on or about 4th of 2026, were you in the area of? The area of Emmons Boulevard and Edwardsport in Wyandotte, Michigan?
Yes.
And is that in the county of Wayne?
Yes.
And when you were there on that date, did officers come in contact with you?
Yes.
And through a search of your person, cocaine, you had cocaine that day?
Yes, I did.
And that cocaine was for your personal use, is that correct?
Yes.
No further questions, if the court satisfied.
All right, thank you. And the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge for the plea agreement. And then, sir, you will be contacted by probation while you're there in custody unless you post your bond, and they will conduct a PSI And then, counsel, you can coordinate the sentencing date with your calendar as well.
Your Honor, I did want to address bond in this matter as well.
Okay, well, bond is currently at $10,000, 10% bond, with the following conditions: not to possess or consume any alcohol or drugs unless prescribed, as well as
Right.
random testing, and use to contact probation upon release to set up that random testing. And counsel?
Thank you, Your Honor. I'm not asking the court to amend any of the conditions other than the costs in this matter, Your Honor. I am requesting a personal bond since my client has pled to a misdemeanor before this court. He does not have a long history, Your Honor, recent history, I should say. He does have a prescription for Suboxone. This is his first drug charge, Your Honor. I guess that's the better way to put it. And I do believe he is 7411 eligible. He, Your Honor, has 4 sons, aged 21, 19, 16, and 14. The 21-year-old actually just had a baby as my client's been incarcerated. So he is a new grandfather, hoping to participate in, his family and helping take care of that new baby, having that experience as a new grandfather, Your Honor. The other children, the other 3, the 19, the 16, and the 14, both are in AAA, AA hockey. He frequently goes to their hockey games and participates as a father. He does reside, those children reside with him. He's also at risk, Your Honor, of losing his house. They've actually given him a notice for today that if he does not try to resolve that issue, Your Honor, he could lose his residence.
Well, yes, so I've made note that both he and Miss Anderson are in custody. And so when that's coming across my desk, I have to, or my computer screen, I should say, then I will address that accordingly. Autumn, what is the other matter that Mr. Campbell was just here for last week? Was it also a possession charge or was it a disorderly?
No, that's my uncle. That's not me.
Oh, I think that was Keith. That was Keith Campbell.
Yeah, that's not me. Tracy and Keith, that's my uncle.
That's right. Okay. I'm sorry to confuse the two. So that case will not come before this court because that's in 34th District Court in Romulus. His uncle Keith and Miss Anderson are the ones that have a matter in this court. Well, they have many matters, one of which is the landlord tenant, and the other ones are possession charges. Well, if you happen to see Miss Anderson, so you can let her know that the warrant's been issued for her arrest since she absconded from excuse me, please, since she absconded from treatment and cut off her tether.
Oh, wow.
Yes. Oh, wow. So what's going on with your felony drug matter in Lincoln Park, sir, from November?
It's the paraphernalia charge. I still have to go to court on that matter, Your Honor.
It's not just a paraphernalia charge. They don't charge a felony drug for paraphernalia, sir.
That's all it was. I promise. Swear.
Well, in any event, there are pending felony drug charges, counsel, and so the court does have concerns for the safety of the public as well as Mr. Campbell. Going to deny the request to amend bond.
But what happened is they keep something.
Did you say that was landlord?
Yes, 25th District Court. But we'll also note your client does have a significant criminal history dated back to 2005, involving driving offenses, some alcohol-related driving offenses, domestic violence matters, larceny matters, and now we have the felony drug charge in November of 25 from Lincoln Park, and then this matter as well. So the court's going to deny the request to amend the bond. The court finds the bond is appropriate $10,000, 10% bond. Bonded conditions are continued. Thank you. Let's go off the record for a moment. Okay, let's go on the record. No, I understand. Well, let's go on the record in the matter of the city of Wyandotte versus Alexis Jimenez 26307 A and B. That's why I got confused today, Dave, when I was getting everybody confused. Because Alexis Castillo, did that one fail to appear? Did Castillo fail to appear?
No, I understand. They pull the file, someone filed an appearance. That's what I was told.
No, I think we all got confused between Alexis Jimenez and Alexis Castillo, and that may have been because of me.
Well, 1015 was gone, whatever that one was.
Really? Okay.
Who was that? Castillo?
Yes, not to be confused with Alexis Jimenez.
They rescheduled it.
All right. And so counsel, your appearance, please.
Your Honor, John Goldpaw, P 30758 on behalf of Mr. Jimenez. Mr. Jimenez, please put your name on the record.
Well, I need you to unmute, please.
Okay, do I speak?
Yes, sir.
Put your name on the record, please.
My name is Alexis Rafael Jimenez.
All right, thank you. And counsel, as to the arraignment.
That's the arraignment, Your Honor, stand mute to the charge, waive a formal reading of those charges, ask to plea of not guilty to be entered.
Court will waive the formal reading, enter plea of not guilty for purpose of the arraignment. And so counsel, here's where I'm going to need either some, I'm not really sure. Your client has retained counsel on another case.
That's correct, Your Honor.
26169 A and B, possession of controlled substance and open alcohol. That's scheduled for April 8th with a retained attorney. This matter, I would like to keep the cases together. However, that's not for another 4 weeks. And so then,
Not on the docket.
right, but you don't have to be on the docket because you're only arraigning them. But my point is that then your client would be potentially in custody for 4 weeks. So I'm going to put this on the docket for March 25th. No, I'm not. March 18th.
JM on North, if he doesn't retain Mr. Burgess, then I will be ready to at least handle something about this.
10:30.
At 10:30 a.m. And counsel as to bond.
Your Honor, Mr. Alexis is 24 years old, has no prior contacts with prior convictions on his record. He's, as I indicated, 25 years old, 24 years old, excuse me. He's single, he's employed, has been for the last year at the metal company in Dearborn. He lives with his mother, stepfather, brothers, and his grandparents. He is has another matter that the West Court pointed out for April 4th. We're asking for personal bond or one connected with the allegations here. This is his first drinking driver's license.
Well, your client must really appreciate the way I'm all in custody because he wanted to get back there so quickly. So,
Your Honor.
Mr. Jimenez, where do you work?
Yep. I'm sorry, Your Honor.
Where is it you work, sir?
Metal Fab Inc. in Dearborn.
Okay. And sir, if you were to test right now, what's in your system?
Alcohol, marijuana, and cocaine.
Okay. Sir, it appears though you may have some challenges in maintaining sobriety from substances.
It has been a very bad month for me, and I know that that is no excuse for me to do what I'm doing.
Well, hold on, sir. Hold on. I don't want you to talk about any of your cases, the factual basis of any of the cases. I'm just simply saying, sir, that it appears as though you're having some challenges right now that you cannot navigate without assistance.
That would not be incorrect to say. Yes. Recently, I have been losing control.
Okay. Are you interested in Are you interested in inpatient treatment, sir?
I'm sorry, what kind of treatment, Your Honor?
Are you interested in inpatient treatment, sir?
Would that be like I'm in there all the time?
Right, to work on your substance and alcohol addiction issues, sir?
I would rather not. I'm going through therapy right now and seeing a psychiatrist to work through my issues, and it's just it's been a very hard month for me, and it's a lot of things that I feel like I'm running away from. I just need to work through them. And I know I've made mistakes and I'm very remorseful. It's just
Okay,
I'm sorry, go ahead.
that's all right. Have you ever failed to appear in court for any reason, sir?
No, this is the first time I've ever been in trouble.
Well, technically second time, because the first time was February.
But he hasn't been arraigned back then yet, so.
Correct. All right, so, are you currently out on bond in any other jurisdiction, sir?
No.
All right, ever failed to appear? Oh, no, I already asked that question. All right, so I'm going to, given the fact that you have a pending matter with this court, albeit you're not on bond in that matter, you now have this offense that's been charged. And so the court, to ensure that you're going to not get into trouble any further while you're waiting your other matters, and to ensure the safety of the public in your appearance in court, the court's going to order a $7,500 10% bond. In the event you post bond, sir, you are not to possess or consume any alcohol or drugs that are not prescribed. You are to not be released without an alcohol tether through the Wayne County Jail. And you are to participate in random testing, and you are to also continue with your therapist.
The
The last one, continue with the therapist.
7,500, 10%.
No alcohol or drugs, random testing, alcohol tethered through the Wayne County Jail. Yes.
Thank you.
Okay, thank you. Have a good day. All right.
Either I will see you next week, or if you get out and you get a hold of Mr. Burgess, make sure he contacts the court or appears on the 18th. You understand that?
When I get out, contact David Burgess and tell him to
Contact
contact
Mr. Burgess. Excuse me, contact Mr. Burgess as soon as possible and tell him what's happening with this case. I will be here next week.
Okay.
Thank you.
Thank you. Have a good day. Let's go on the record in the matter of the state of Michigan versus Richard Bethia, 26228.
Good afternoon. You probably have now, P86281. I have Mr. Richard Bethia. Mr. Bethia, please state your name.
Good afternoon, Your Honor. My name is Richard Bethia.
All right, thank you. And so today is the date scheduled for the preliminary examination in this matter. And counsel?
Thank you, Your Honor. We did a preliminary exam today. However, there was an offer tendered to my client for a plea, which he wishes to take before this court today.
All right, if you'd like to please place that on the record.
Yes, Your Honor. It was to dismiss counts 1 through 3. The people were amending the information to add a reduced count, which is attempted police officer assaulting, resisting, obstructing, Your Honor.
And all 3 charges are being dismissed, even the driving while license suspended?
Yes, and including the habitual.
Counselor, your attorney worked out a very good deal for you. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You guys were out. All right.
3.
We need a few of them. Yeah, thank you. And sir, you heard the plea that was placed on the record, and as to the amended charge, sir, of attempt resisting and obstructing an officer, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights. You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am.
And you as well, sir, understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
Oh, ma'am.
Counsel, if you can please pardon your client.
Yes, Your Honor. Richard, on or about February 23rd of 2026, were you in the area of 3995 12th Street?
Yes, ma'am.
And that's in East Forest, Michigan?
Yes, ma'am.
Is that in the county of Wayne?
Yes, ma'am.
And when you were at that location, at some point, officers had come into contact with you, is that correct?
Yes, ma'am.
And they were trying to stop you, is that correct?
Yes, ma'am.
And you did not stop at that time?
No, ma'am.
And while they were trying to stop you, they tried to place you under arrest, is that correct?
Yes, ma'am.
And they tried to have you place your arms behind your back to place you under arrest?
Yes, ma'am.
And you were not doing so, is that correct?
No.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea. I don't know that this is the best resolution, but I also don't have any of the discovery that counsel's been able to review or not. But given the criminal history and the matter that your client's currently on probation for, in this pending matter, somehow, sir, your attorney worked out a really good deal for you. Because I have to tell you, you're a danger to society with your behavior. In any event, sir, you will have a sentencing date. Counsel, you can coordinate that with your calendar as well. And then the court will order bond and conditions are continued.
I did want to address bond.
All right, bond is currently $250,000, 10% bond with the following conditions. Those conditions being not to operate a motor vehicle, Wayne County Jail, tether, house arrest, not to possess or purchase a firearm or any other dangerous weapon, and any other standard conditions.
Thank you, Your Honor. I am asking the court to reduce bond today, Your Honor. My client has taken responsibility and entered a plea with this court. He has a 4-month-old daughter at home, Your Honor, as well as a 5-year-old son that he is usually responsible for caring for, as the mother of those children just started back at work. So he's typically responsible for caring for those children while she goes to work currently, Your Honor. Additionally, he is working himself. He resides at his grandmother's home, Your Honor. I am asking the court to reduce his bond with a GPS tether and house arrest requirement if the court sees that's fit. He is not able to pay that bond, Your Honor. So I do ask the court to do so. I do not believe he has any history of not appearing to court.
Okay, so Mr. Bethia, if you have these children at home that you're responsible for, then I'm not really sure why you are behaving in the manner that you are behaving in, sir, and operating vehicles and in that manner and leading police on chases, because that seems to be you're on probation for that. You're on probation for fleeing and eluding a police officer. November 4th of 25 is when you were sentenced. February 23rd of 26, you now have another charge of that, and the prosecuting attorney's office thought it appropriate to enter into this plea.
I think that's done.
Well, counsel, the court will note that, well, Mr. Muhammad, you're present. Would you like to address bond?
Yes. Good morning, Your Honor. Muhammad on behalf of the people. Judge, my understanding is the defense is going to request a GPS tether on the defendant be placed on house arrest. Considering the defendant's pleading guilty to just one count of Arndo, considering some circumstances that were disclosed to my office today. I think I'll leave it to the court's discretion. I think it's fair. But I'll leave it to the court's discretion.
Okay, counsel, I'm going to see you both in chambers because I think I need to be apprised of some of this, given that your client's currently on probation for the exact same charge. So let's go off the record. You're not muted. Richard Bethia, 26228, wait, is on me? Okay. 228. And appearance for the people again for the record, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Probably have that be 86281 on behalf of Mr. Richard Bethia.
All right, and Mr. Bethia, your name again for the record, please. All right, and so the court has been brought up to speed on the basis for the plea at hand. The court has heard arguments regarding the amendment of bond. The court will note that the $250,000 10% bond will be amended. It's not being amended to a personal bond. However, as Mr. Bethia had entered into a plea to a misdemeanor, and the 3 felonies and habitual third offense have been dismissed.
And Judge, just for the record, my apologies to interrupt. It's a proof issue in regards to the fleeing and the defendant operating the vehicle, just for the record.
All right, thank you. The court will amend the bond to be $25,000 10% bond. The balance of the conditions remain. The court has some serious concerns for the safety of the public and community, given the allegations in this matter and the fact that your client is currently on probation for a felony of a similar nature. So the court is going to will grant your request to amend the bond based upon the plea. However, the court's still requiring the balance of the conditions and then $25,000 10% bond.
Thank you.
Thank you. Have a good day.
So what was going on there? Hypotheses, people. Hypotheses. I need to know in the comments. Something was happening right there. That guy got the sweetest deal. He's out on probation for the same nonsense. You have to wonder if there may have been something hinky with the police going on. I don't want to. I don't want to toss that out there because I don't know. But it obviously behind closed doors, minds changed about things. More specifically about the charges, right? Man, it was another roller coaster of a night. You know, some decisions you agree with, some you don't. They're all interesting, some kind of crazy. Guy showing up drunk in court, trying to fool the judge. Judge Oakley is not the person to mess with when it comes to that type of stuff. And Judge Simpson, he had one of those kind of legendary Simpson days where it was just shot after shot after shot after shot. And the fact that we saw Jeremy Shue, of all people, ladies, Rod, thank you so much very much. Mama, thank you so much very much. Hey, Big Tiff Dog out there, Kiranoff. I know Hutch is out there somewhere. Eileen, Charlene, Shiloh, Milo. Are you there, Milo? Guys, I am your lone wolf Uzi. And I'm your host for these here little get-togethers where we watch these court cases, and I'm your humble curator for this here little court gallery where we all gather. And I do this every single night. I call it the Same Wolf Time, Same Wolf Channel. 8 p.m. Central Time, 9 p.m. Eastern. Come on by. I'll be here tomorrow night. Not Saturday. Saturday, we're going to be on at 11 a.m. Central Time. We're going to do brunch. And then I may have like a premiere or something Saturday night. Maybe Sunday night too. I don't know. I'm thinking about it. I'm thinking tonight. I got lots of cutting room material. Cutting floor material. What am I trying to, I don't know. Words. Ladies and gentlemen, you know, I gotta be done. I am your Lolo Fusel, and I am. Oh, look at the puppies sleeping on the couch over there. He's cute. Good night, Michelle. Good night, Snacks. Good night, Becky. Good night, Felix, Patrick, Rahul. Arr. Oh, Gemma, I don't think I even said hello to you. Hello. And goodbye. It's good seeing you. Good seeing everybody. Thank you all so much for hanging out. Thank you so very much. And Hutch for that $10 donation. Golly, I almost forgot about that one. You know, I almost let it go. But I had to have something for this little segment. So, you know, better that than nothing, right? Because I got nothing else. We're done. Go. You. Go watch some of Hutch's channel. Or go watch more of mine. Yeah. That's even better. Bye.